Hello everyone. Warm good evening all. Firstly, I would like to thank you for giving me this opportunity, and it's my pleasure to share an important topic to you. My name is Jineesha P Unnikrishnan. I am doing my LLM at Government Law College, Kozhikode. And today I'm going to be speaking to you about the topic limited liability partnership. In short, we can call it LLP. So before going to the further discussion about the topic, you just read the slide. Here are the contents to further. Here are the contents that including it, and you just read the slide. And these are the things intend to say to this topic. So let's go into the topic. Let me remind you one more thing. That is, when I say here, all of you read each slide. Okay. So move on to the topic, that is limited liability partnership. Let's give an introduction. So here we know that a new trend that has been observed of late is that more and more entrepreneurs have started opting for limited liability partnership. So there is a question arises, but what is limited liability partnership? So before answering this question, I will explain you the reasons behind the emergence of the LLPs, that is limited liability partnership. Till a few years back, there are used only two forms of the organizations. First one, limited liability organizations. We know that is company. Then another one is unlimited liability partnerships. That is partnership or the proprietorship. Okay. So both these forms of organizations have their own plus or minus. So there is a limited liability of the owners in a company as compared to the partnership or the proprietorship, which are easy to form and to operate. But the small business and professionals usually tend to opt for the partnerships as they are easy to form and operate. So here, we know here what I say that the limited liability partnership, that is a typical partnership form of the business, suffers from the problem of unlimited liability. Okay, the liability of the partners of a firm extend right up to their personal assets. So this makes the regular partnerships undesirable for a lot of entrepreneurs. One solution for this issue exists in the form of limited liability partnerships, better known as LLP. So here the second point is that everything is better with friends. What I say that everything is better with friends? That is, to understand an LLP, it is best to start with a general partnership. That is, a general partnership is a for-profit entity that is created by a mutual understanding between two or more parties. So the partners of a typical partnership firms have unlimited liability towards their collective debts and the legal consequences. And this is mean that their own assets are liable for attachment for meeting the firm's debts and liabilities. So, and limited liability partnership solves this problem. Here, an LLP has all the basic features of a regular partnership firm, except that the same legal entity starts unlimited liability of the partners. Consequently, the limited liability partnerships have legal existence, and the identity separated from that its partners. Furthermore, its partners have limited liabilities. This is an introduction about the topic. So let us look at the definition of the limited liability partnership, and I will tell you later how it is came to be in India and which came under the Act in India, etc. So look at the slide. That is a limited liability partnership definition. Section 2 Clause N of the LLP Act 2008 defines as a limited liability partnership means a partnership formed and registered under this Act. That is, the LLP is a partnership registered under the Act. That is, since in the Limited Liability Partnership Act 2008 specifically governs limited liability partnerships in India. The provisions of the Indian Partnership Act 1932 are not applicable. This is an important point. No, the provisions of the Indian Partnership Act 1932 are not applicable to the LLP. They only apply to the traditional partnership firms. So coming to the next area, that is LLP in India, that is Limited Liability Partnership Act 2008. That is, once the definition is understood, the question is that arises, that is why an LLP? That is why an LLP? That we know that is the most LLPs are created and managed by group of professionals who have lot of experiences and clients among them. So the partners in LLP may also have number of junior partners in the firm, etc., who work for them in the hopes of someday making full partner. These junior partners are paid a salary and often have no stake or liability in the partnership. The important point is that they are designated professionals. We coming to that area, what is the mean by designated partner? So here they are the designated professionals who are qualified to do the work that partners bring in it. So we can move to the area that is the LLP around the world. That is how the LLP around the world. There is an important thing is that the LLP exists in many countries with varying degrees of divergence from the US model. In the most countries, an LLP is a flow-through entity intended for professionals who all have an active role in managing partnership. So there is an often list of approved professionals for LLP, such as lawyers, accountants, consultants, architects, etc. So the liability protection also varies, but most countries LLPs protect individual partners from the negligence of any other partner. So coming to the area that is LLP in India, the Limited Liability Partnership 2008 was published in the official Gazette of India on 9th January 2009, and it has been effective since 31st March 2009. So in India, you just read the slide. It came as a result as the recommendations made by the several committees, expert committees like Budd Committee in 1972, Nair Committee 1992, Abid Hussain Committee 1997, Gupta Committee 2001, Naresh Chandra Committee 2003, and the J.J. Irani Committee 2005. In India, as in many
ഒരു സംശയം ചോദിച്ചോട്ടെ ജിനീഷ. ഓക്കെ, സ്ലൈഡ് വിസിബിൾ ആണോ എന്ന് അറിയാൻ. ഓക്കെ, താങ്ക് യു.
Visible, sir?
Okay, ipo visible ആണ്. Okay.
May I continue, sir?
Yes, sir.
So, in India, as in many other jurisdictions, a limited liability partnership is different from limited partnership. That is, limited liability partnership is different from limited partnership. A limited liability partnership operates like a limited partnership, but a limited liability partnership, each member is protected from the personal liability, except to the extent to their capital contribution in LLP. In India, for all purposes of taxation, service tax or any other stipulated tax payment, an LLP is treated like any partnership firm. That is, an limited liability partnership shall be a body corporate and the legal entity separated from its partners, and it will have perpetual succession. And in Indian Partnership Act 1932 shall not be applicable to LLP, and there shall not be any upper limit on the number of partners and in LLP, unlike an ordinary partnership firm where the maximum number of the partners cannot be exceeded 20. That is about the Limited Liability Partnership Act. Now we can move to the another area, that is characteristics of the LLP. What are the characteristics of the LLP? First one is the minimum number of partners in corporate LLP is 2. That is defined under Section 3 of the Partnership Act 2008, Limited Liability Partnership Act. Here, what I say that there is no upper limit on the maximum number of the partners of LLP. Minimum number is 2. Among the partners, there should be a minimum 2 designated partners who shall be individuals, and at least one of them should be resident in India. This is one of the characteristics. Next one is that separate legal entity. We studied the company law in lower classes, LLP classes. So, like a company, LLP has also separate legal entity. So, the partners and the limited liability partnership in the distinct from each other. This is like a company where directors are different from the company. This is a second characteristic. Third one is no requirement of minimum capital. In case of the companies, there should be a minimum amount of capital that should be brought by the members or owners who want to form it. But to start a limited liability partnership, there is no requirement of a minimum capital. Then another point is no requirement of the compulsory audit. That is, we have learned to the Companies Act, that is, all the companies, whether the private or public, irrespective of their share capital, are required to get their accounts audited. But in case of the limited liability partnership, there is no such mandatory requirement. And limited partnership is required to get the audit if done by two conditions are, the first one, the contributions of the LLP exceeds 25 lakhs. Another one is annual turnover of the LLP exceeds 40 lakhs. Then another characteristics is the low cost and less compliance. That is, the cost of forming an LLP is low compared to the cost of incorporating a public or private limited company. That is, the compliance to be followed in LLP is low. Then another one is the sharing profit. That is, all partners of the limited liability partnership share profit of business just as partners of the regular firms. They are, however, free to decide the ratio in which they will share the profit. And these are the characteristics. One more added to that is, the rights and duties of the designated partners are governed by the LLP agreement. We move on to that area. That is what is meant by LLP agreement later. So they are the directly responsible for the compliance of the all provisions of the LLP Act 2008 and the provisions specified in the LLP agreement. These are the characteristics of the LLP. The next one is the benefit of forming an LLP. What are the advantages of the LLP? That is, the first one is the liability of each partner is limited to his share as written in the agreement filed at the time of the creation of the LLP, as compared the partnership firms which have unlimited liability. Then another one is low cost formation, that is easy to form. Then another one is partners are not liable for the act of each other. That is the liability. That is, the partners are held liable only for their own act. As compared to the partnership firm, that is where they can be liable for the act of their partners as well. But in the case of limited liability, there is no such a kind of liability. Then another one is that less restrictions and complaints are enforced and LLP by the government as compared to the restrictions enforced by the company. Then another one is the juristic legal person LLP can. This is an important one. So LLP can sue in its name and be sued by others. That is, the partners are not liable to be sued for dues against LLP. This is the advantage of the LLP. Sorry, sir. Sorry, sir. Screen. So, benefit of the advantages of LLP, we can cover it. Then next one is a designated partners, who is according to section 7 of the Partnership Act 2008, defined as a designated partners. Before going to that, that is the advantages of the LLP. Then who is the designated partner? The partners, designated partners are the we know that any person can be a partner. Then every LLP shall at least 2 designated partners who are the individuals. At least one of them shall be resident in India. And in case of a limited liability partnership in which all the partners are body corporates, at least 2 partners shall nominate their respective individuals who are act as a designated partners. This is a designated partners, and one of the nominees shall be resident in India. Resident in India. This is a designated partner. And another one is, next one is who cannot become partner. We already studied that who cannot become partner. That is the person who he has been found to be unsound mind by a court of competent jurisdiction and the finding he is in the force, and he is undischarged insolvent, or he has applied to do adjudicated as the insolvent and his application is pending. The HUF or its Karta cannot become partner or designated partner in LLP. And these are the persons who cannot become the partner of the LLP. Then we can, next one is a disqualification. How to disqualify the designated partner? What are the reasons behind the disqualification? He has at any time within the preceding 5 years has been adjudged insolvent. Then the suspended or has at any time within the preceding 5 years suspended made it to his creditors and has not at any time in the preceding 5 years made composition with them, and it has been convicted by court for any offense involving the moral turpitude, sentence in respect thereof imprisonment for not less than 6 months. Then another provision is added, that is, he has been convicted by a court for an offense involving section 30 of the act. The section 30, what I said, I will including the PPT, that is, the section 30 is the unlimited liability in case of fraud. Any person can conduct, knowingly carries any fraudulent act with intent to defraud creditors of the limited liability partnership shall be punishable with imprisonment fund for a term 2 years, and with the fine shall not less than 50,000 rupees, but which may extend to 5 lakh rupees. So these are the grounds for disqualification of the designated partner. Then another one is the disadvantages of the LLP. What are the disadvantages? We know we covered that area, that is the advantages of the LLP. Here the disadvantages of the LLP. Here, any act of the partner without the other partner may be bind the limited liability partnership. So limited liability partnership cannot raise money from the public. This is the one of the disadvantages. Then next one is that the penalty on non-compliance. But I say that the complaints that is to be followed by the LLP is minimal. So, but if these complaints are not completed one time, then the LLP will have to pay heavy penalty. Even if the LLP does not have any activity in the year, it is required to file returns with the Ministry of the Corporate Affairs annually. If it is fails to file the returns, the heavy then the penalty goes to heavy, imposed to the LLP. This is a penalty on non-compliance. This is another disadvantage. Next one is a winding up and dissolution. That is, we know that is the minimum 2 partners have to form the LLP. So the minimum 2 partners is required to form an LLP. So if the minimum number of partners is below 2 for 6 months, then the LLP will be dissolved. So it may be dissolved in LLP, unstable, and to pay its debits. Then another one is difficulty to raise capital. The LLP does not have the concept of equity or shareholders like a company. So angel investors and ventures capitalists cannot invest in an LLP shareholders. This is because the shareholders must be partners in the LLP and have to take up all the responsibilities of the partner. Thus, but I say that the angel investors and ventures capitalists prefer to invest in a company rather than an LLP, making it difficult for the LLP to raise capital. So this is the disadvantages of the forming company. Then another one is important one is, that is, what is the difference between LLP and the traditional partnership firm? You just read the slide. The basic difference between the LLP and the partnership firm with regard to the liability of the partners. This is an important or basic difference between the LLP and the traditional partnership firm. And the liability of the partners, that is, in case of limited liability partnership, there is no such mandatory requirement. And that is, the LLP structure, the liability partner is limited to his agreed contribution. So the LLP is a separate legal entity. We know that in a partnership firm, every partner is liable jointly with all other partners, and also severally for all act of the firm done while he is a partner. So under the LLP structure, the liability of the partner is limited only his agreed contribution. This is an important point. Further, no partners is liable on account of the independent and unauthorized act of the other partners, thus allowing individual partners to be shielded from joint liability created by another partner's wrongful act or misconduct. And that's another, this already the fourth, fifth, sixth point, already all points are covered. Already we covered that previous session. Then next we can go through the difference between LLP and the company. What is the difference between LLP and company? Here also the major difference between LLP and the company is, that is, less regulatory and other compliance regulations applicable on LLP, which makes it easy and cost effective to management other than the company. This is an important difference. So the registration much more easy when it comes to an LLP, but not company. Then an LLP agreement is like the memorandum of association and the articles of association. And in LLP, the change in name or registered office address is very simple than the company. Then non-mandatory time period for meetings in LLP, and mostly ownership and management be in the hands of the same person. So when it comes to the LLP, in case of the company, no individual director can conduct the business of the company, but in an LLP, each partner has authority to do all unless expressly provided by the partnership firms. So this is the difference between LLP and the company. Next, we can move to the setting up of limited liability partnership. The setting up by the LLP agreement, incorporation, then name of LLP. That is, what is LLP agreement section 23. The LLP agreement, just to read the slide, that is the LLP agreement, and these are the contents of the LLP agreement. And the LLP agreement is the limited liability partnership agreement, means any written agreement between the partners of the limited liability partnership or between the limited liability partnership of its partners, which determines the mutual rights and the duties of the partners and their rights and duties in relation to that limited liability partnership. So this is an LLP agreement. And the contents of the LLP agreement, that is the name of the LLP, name and address of the partners and designated partners, form of contribution of and interest on contributions, profit sharing ratio, remuneration of the partners, and these are the contents of the LLP agreement. Then another one is incorporation document, section 11. That is a incorporation. That incorporation document, that means I say that you need to choose a business name that is unique and not similar to any other business. So a registered address will need to be included in the incorporation of the documents. Here, in case of the incorporation of the document, the two or more persons associated for carrying on a lawful business with a view to earn the profit will be required to subscribe their names to an incorporation document for getting an LLP incorporated. And also the incorporation documents to be filled in such a manner with the details of the designated members, details of other members, the partnership main business activities, and etc. So it is prescribed in the manner which is the register of the company of the state in which the registered office of the LLP is to be situated. So these are the this is about the incorporation document. So another important section is section 12 clause 3, that is, if any of the fraud or mistake or is found, that is a person making a statement about the compliance of the LLP Act referred to these contents, so it said provisions is not to be false or doesn't believe to be true, so he is fined with 10,000 to 5 lakh and imprisonment extend to 2 years. So this is about the incorporation document. Then another one is the effect of the registration. Then effect of the registration is under section 14 of the LLP Act. That is already we says that about that is on getting the certificate of registration of LLP, enjoy the status of body corporate and become legal entity separated from its members, and it shall have following. That is already we says that can sue and be sued, acquire, own, hold, develop or dispose property, have common seal, can do and suffer such other act and things as bodies corporate may be lawfully do and suffer, and this is the effect of registration. They can get every rights. So another one is the provisions relating to name and the LLP changes. Here every limited liability partnership shall have their words, that is limited liability partnership or the acronym LLP in the last words of this name. We that is the name guidelines are similar to companies, and the name can be reserved through run LLP. One resubmission for 15 days is allowed to be filed within following enclosures like that is a certified copy of the consent of the partners involved for the name change and a copy of the existing agreement, LLP agreement, then trademark copy or copy of the registration of the certificate, etc. So under the three different situations, LLP changes its name. Section 17, it says that central government directed LLP to change its name. Section 18, register of company directed LLP to change its name. And section 19, if it voluntarily wishes to change its name. So these are the circumstances the LLP can change its names. Then in another one is there is a penalty. The penalty for the improper use of words LLP, section 20 is defines. That is, each person carrying on such business which is not incorporated as LLP and yet using the term LLP shall be punishable with the term fine not less than 50,000 and which may extend up to 5 lakhs. So these are the provisions relating to name of the LLP and changes. Section 15 to 21 of the LLP Act 2008 defines as this provision. And another one is a conversion into limited liability partnership, section 55. That is section 55, that is a conversion from firm into limited liability partnership, and it's all are related to the schedule of the specified schedule under the a particular act. And section 56, conversion from private company into limited liability partnership. Section 57, conversion from unlisted public company into limited liability partnership. And section 58, registration and the effect of the conversion. So there is another point is to be added, that is then alteration of the LLP agreement, that is to be filed within 30 days from the date of amendment in form 3 along with the following documents like initial LLP agreement, supplementary or altered agreement or optional agreement, etc., etc. So we say that conversion of the company, then a conversion of company into LLP, that is any existing private company or existing unlisted public company can be converted into LLP by complying with the provisions of the clause 58 the schedule 3 and 4 of the LLP Act. So the form is 18. Form 18 needs to be filled with the registrar along with the form 2 for such a conversion after getting the name approved. So this is a conversion. Then another one is an important point is that winding up and dissolution. Section 63 to section 65 of the LLP Act defines as that 2008 defines as a winding up and dissolution. So winding up by the tribunal. Section 64. Here a limited liability partnership may be wound up by the tribunal. That is, if the limited liability partnership decided that limited liability partnership to be wound up by the tribunal. First one. Then another one is if for a period of more than 6 months, already we say that the number of partners of the limited liability partnership is reduced below 2. So in that kind of that circumstances, the company should be wind up. Then another one is if the limited liability partnership is unable to pay its debits. In that kind of circumstances, the company LLP should wind up. Then if the limited liability partnership has acted against the interest of the sovereignty. Sovereignty means that is sovereignty, that is integrity of India, that is the security of the state or public order. So in these type of circumstances, the company wind up. The LLP, limited liability partnership, wind up. Then if the limited liability partnership have made default in filing with the registrar, the statement of account or solvency or annual return for any 5 consecutive the financial years. So in these circumstances also the company should wind up. And also these are the circumstances, the winding up and dissolution of the LLP, section 63 to section 65. Then another one is the taxation of LLP in India. Here we know that in India, the government has notified the LLP would be taxed in the same form as partnerships. That is, tax would be levied on the LLP and the partners would be exempt from the tax. And we studied that is as per section 2 clause 23 of the Income Tax Act 1961 state that meaning of the firm. So the firms under the persons who have entered into partnership with one another are called the individually partners and collectively a firm. And the name under which their business is carried on is called the firm name. Here, as per the Income Tax Act 1961, firm shall be included LLP. So definition of LLP Act already is so that is to close N of the LLP Act 2008. So while computing the income tax, we studied that the income tax will be computed under the 5 heads of the income. So here the LLP, in LLP the tax is be calculated under the income from house property. Here, if any property owned by the firm or LLP received from that, then another one is the capital gain, that is at the time of the dissolution of assets of firm or LLP, as case may be. Then another on the basis of the income from the business and profession. Then another one is income from other sources like interest on investment held by the firm of LLP, etc. So these are the important points about the tax LLP in India. So we can move to the another area that is an important case law regarding the LLP. There is a case that is Jayamma versus a registrar of firms. Here, this is in this case, the fact is that the partnership deed was executed between an individual and an LLP, and refused the registration of the partnership firm on the ground that LLP cannot be a partnership firm. So this is a fact about that case. Here, this comes from the difference in provisions of the Indian Partnership Act 1932 and LLP Act 2008 related to the liability of the partners. And the Kerala High Court observed that the difference in provisions under the Indian Partnership Act 1932 and relating to liability of the firm of the individual partners would not stand in the way of the constitution by the partnership with the LLP. Here, what is mean that the High Court ruled that LLP cannot have a disqualification from entering into a partnership with an individual or other persons. This is an important case, Jayamma Xavier versus a registrar or firm, 8th April 2021. Then we can move to the another area, that is the multiple choice questions. This is a simple question that is already we covered through this presentation. First question is, publication of name and limited liability is provided in which section of the LLP Act 2008? We simply says that it is section 21 of the LLP Act. Is LLP Act section 21 is says state about the name and the name, publication of the name of the in limited liability. Then another question is, a limited liability partnership is, we already said that what is a limited liability partnership is a legal entity separated from that of its partners, and also it is a body corporate. So answer is answer D, option D. Then another one is, whether HUF, Hindu Undivided Family, can become partner in LLP. Simply we can say is that no, HUF cannot become partner in the LLP. Already we covered that is who is not a partner, who is not the partner of the LLP. So next question is, how many designated partners are required in LLP? We know that is at least 2 partners. Maximum number is unlimited. So this is option 4th question. The option is A. Then another next question is, who is the authority to grant compounding of offence under LLP Act? This is a central government, not the registrar of firms, not the registrar or registrar of the cooperative firms. This is the central government is the authority to grant the compounding of offence under the LLP Act. Let me conclude my topic. That is, we hope you understand that topic, that is LLP. Already we say that LLP is a body corporate and formed the incorporated under the LLP Act 2008, and it is a legally separated entity from that of its partners. And also already also the liability of the partners is limited to their agreed contribution in the LLP. And it contained the elements of both the corporate structure as well as the partnership firm structure. And also, moreover, the partner is not responsible or liable for another partner's misconduct or negligence, as there is no joint liability in the case of LLP. So this is about the topic limited liability partnership. So hope you understand about this topic. So let me next, that is references. I will refer this Limited Liability Partnership Act 2000. It is a simple act. Then another references is that. So I would like to thank all for the patience to hear me. So thank you.
അങ്ങനെ നോക്കുമ്പോൾ നമുക്കിത് മനസ്സിലാവും.
see, 80 Article 80 is what about the composition? What about the Council of composition of the Council?